Shalom, this is your Ark. Yah is magnified, and I'm back with another informative video. I titled this video, The Consequences for Failure to Appear and or Respond. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now as you all know, I've been doing a continuous series of videos simply telling you all why and showing you all why you should in fact respond back, study, and learn so you can get yourself off of child support, okay? Or even to stop it before it starts. Because, the ball is in your court and you must learn these things, all right? Anyone can post up a video of an individual going into court without any understanding of what they're doing and going in an illusion. It's a difference from someone going into court knowing the rules and knowing what to say compared to someone who don't know the rules and don't know what to say and simply go into these courts and make a fool out themselves. Okay, so don't be deceived by watching people videos who's trying to tell you all not to show up for court because that's going to happen to you. No, that only happens to people who do not know the rules of the game or who do not know how to play the game. That's like me on the court, right? And I'm playing a 5-year-old, right? The 5-year-old, he don't know the rules of basketball. I'm out there dogging a 5-year-old, taking them to court, schooling them, dunking on them, doing all this wild stuff to a 5-year-old. I can do that. Why? Because the 5-year-old, for one, he's not advanced enough. For two, he's not skilled enough. For three, he don't know the rules of the game. So I can walk all over him. And that's you guys when you go into court. You guys are going against people who went to 6-7 years of college for this information. You see? So they know the rules. They know what's going on. You guys don't. So when you get into these courts, you don't know the rules, the civil procedures, so you go in there and make a fool out yourself. All right? And the channel that's putting that information out there, they call themselves a destroyer, but destroyers don't run. Okay? Conquerors don't run. People who come and cause destruction, they cause destruction, meaning they came and showed up, destroyed it, and rolled out. Okay? Destruction don't run. All right? Destruction don't say send a mail back. Destruction say meet me head on. That would a destroyer do. So you cannot call yourself a destroyer in one breath, but in another breath tell your individuals or people that's following your channel to run from the person that they're supposed to so-called be destroying. It just don't make sense, guys. So if that individual is telling you all to send the mail back, that clearly should let you all know that he cannot help you in your situation. Because if he could, he would have told you so. Obviously, he can't. That's why he wants you all to send the mail back and continue to run. And that's what I've been telling y'all from the beginning. Pay close attention to what people are saying. Understand what's being placed before you. All right? You have one person giving their own interpretations of what they believe the statutes and codes say. And you have another person, such as myself, who's showing court documents, showing legal information, and showing what the courts are actually ruling on and making the decisions. So which one you rather listen to? Are you rather listen to someone who's giving their own private interpretation, who falsely interprets the doctrines, statutes, and codes, or you rather listen to someone who's telling y'all to face people head on, showing evidence of what will happen to you if you decide to or you decide not to? It's your path, it's your choice. Only thing I can do is give you the other side of the coin. Okay? But let's continue. So now, as you all can see, this document, which is an order, was filed on April 30th, 2014, right? Right. Let me zoom out. Okay, so now as you all can see, this was in fact done in the District Court of Larimer County, Colorado, with the address, right? Let's continue reading. The people of the state of Colorado in the interest of blank child. So understand what you guys are reading on the screen so you get better understanding. But let's continue forward. Upon the petition of Larimer County Department of Social Services, who is the obligee. You see? And the child's mom, I crossed her name out, who is in fact also they consider to be the obligee. Let's continue. And concerning the father, who they've marked as obligor. Okay? But like I tell you, all unrebutted statements are considered to stand as truth. So let's continue. Attorney or party without attorney, right? As you all can see, the Larimer County DSS CSE unit was represented by counsel, okay? That was the party with attorney. Case number I crossed out for both the case number and the 4D case number I crossed out, but let's continue. This was in fact a what? An administrative order of default. Okay? So we're going to read this. We're not going to read the whole thing. We're going to read the first page, and we're going to go to the last page so I can show you all that the default order was in fact signed. But let's continue on. It states, the Lorimar County Delegate Child Support Enforcement, CSE, units issues this order of default pursuant to subsection 26-13.5-106, Colorado Revised Statutes, CRS, and submits it to the court for approval. Okay? So they did what? They, in fact, submitted an administrative order for default to the court upon approval, or for it can be approved and adopted by the court. Okay? But let's continue. Venue is proper, right? Number one. Number two, the state of Colorado has personal jurisdiction over the obligor. Now let's find out, how did the state of Colorado get personal jurisdiction over the obligor? Let's read number three. The obligor was personally served, the obligor was properly served with a notice of financial responsibility and failed to respond within the time allowed by what? By law. Okay? Let's continue to kill these individuals softly, man, with this truth. Because the truth will set you all free. You must be willing to face these people head on. Because you will lose if you don't. So you mind what? If you're going to go down fighting, man. Don't go down like a coward running. Go down fighting. Let's continue. A verified affidavit of non-appearance is attached. So who's going to rebut this information? No one's there to do so. So let's see if it was adopted. Okay? Let's go to the next document. Let's zoom in. And it's page number 5 of the document. Let's continue. As you all can see, it was done on dated 4/29/2014. Signed by who? The county attorney, acting on behalf of the county. But let's continue. And it was approved by what? Order approved by the court, with the judge's or / magistrate signature on it. Okay? Now let's read what it says at the bottom. This is an order or judgment entered in a proceeding in which consent is not necessary for the matter to be heard by a district court magistrate. Any appeal must be taken within what? 21 days pursuant to the rules that I'll be telling you all to follow. Let's continue. Rule 7A of the Colorado Rules for Magistrate. Alright, so again, guys, this order was adopted. It was approved. So my uncle reached out to me. He has a default order against them. Right? So now, if he come to me for assistance, the first thing we got to do is what? Address the default. So what he's going to do anyways, he still have to go to what? The same place that he did not want to go into, or the same place he never been before, known as the court. So why run? Why run? Understand what's going on. Get proper understanding. Because they will default you. This is more evidence, more facts, more proof, more truth. This is how you face the people head on. This is how you destroy an agency. Okay? You must understand what's going on. You must be willing to fight. If you're not going to fight, then roll over, take it, and pay these people. That's it. That's all. But you send the mail back, we'll end you in let's go back, and a administrative order for default that will be adopted and granted by the court. Okay? And this was done back in 2014. And my OC just reached out to me. Okay? So again, let's continue to apply that pressure. If you all need my help, hit me up in my email at y'ismagnified@gmail.com. All right? That's all I'm going to do for today. I may come back with more. You know, it all depends if I got time on that. I have a lot of documents I have to draft up and everything else. But again, guys, this is the truth. And the truth is before your eyes. But I'm not going to hold y'all any longer. Enjoy y'all day. With that being said, I say shalom.